This episode is the second in a two-part series covering corporate formation and corporate governance. In the first episode, we talked about entity selection, the documents required to file with the state and the federal government, and documents to keep your company in good standing, as well as the corporate shield. What is it? Why is it important? And how to keep it in place. Now, in this episode, we're going to talk about why all of those documents that we talked about in the first episode are so important when it comes to selling your company. In addition, we'll talk about an operating agreement and some of the nuances around a buy-sell agreement, as well as cover the Corporate Transparency Act of 2020, which just became effective this year, January 1st of 2024. So if you're a business owner thinking about forming a business, then this episode's for you. We've kind of gone through, I think, the documentation, formation, entity selection, and now it's time to sell the company.
All right.
And again, we've talked a little bit about just all the record keeping that you should do, and how it makes it really important. From a purchase and sale agreement. So you're going to have a buyer coming at you, looking at all those documentation, but you're also going to rep and warrant that your books are,
right.
So maybe talk about a little bit about and this would fall under the fundamental reps in a transaction. Talk a little bit about when you're selling your corporation, why that becomes important as well. And not for the buyer as much, but for the seller.
Absolutely. First, a real quick note on fundamental reps. The reason we refer to fundamental reps here is because in a sale agreement, sometimes there will be representations that are only effective for, say, a year or two. And then there are reps that the buyer wants to be able to rely on forever. Those are typically referred to as fundamental reps.
Right.
One of those is always authority.
Right.
Does the company have authority to enter into this sale transaction, to sell the business? And the buyer is going to want to see that they have the right people signing the documents and that the right steps have been taken to authorize the sale. So how does that relate to shareholder meetings and director meetings? Well, the buyer is going to want to know who the officers of the corporation are. The buyer is going to want to know who the directors of the corporation are, because the directors are the ones who can pass a resolution saying now we're going to sell the business. They're also going to want to know who are all the stockholders. And there are two different reasons they may want to know that. If they're buying stock of the business, so they're going to buy the corporate entity, then I think it's pretty clear they want to know who they've got to pay. And they don't want somebody showing up later saying I'm a stockholder. So that's one reason. The other reason is in an asset sale, for example, the buyer is going to want to make sure that they've gotten that the company has gotten the necessary approvals to sell the assets. And in a sale of assets, you have to have not only board approval, you also have to have shareholder approval.
Right.
So knowing who those entities are, having good records of who was elected as a director at different times, having a good stock ledger that shows who all the shareholders are, those are critical from the buyer's perspective to being able to go ahead and do the deal at any price. That's why, from a seller's perspective, you've got to have that documentation. You've got to be confident that it's accurate so that you can make these representations and warranties to the buyer, give them assurance that they are getting the business they think they're getting.
So here's the kicker to that. This will probably make you sit up and pay attention. Usually the rep and warranty is tied to the purchase price of the transaction.
Oh, absolutely.
So you're not rep and warranting that this is happening and you sold the company for $5 million and this rep's $1 million.
No.
It's for the entire purchase price of the transaction. So it's really important to understand that. Anything else on on selling and governance and formation that you've got in your notes?
Well, I do want to go back to this is the situation other than selling, but it has to do with governance and record keeping, and that is it's really important when you're just starting the company out again to keep all these records carefully. Not so much for looking forward to the sale, but just to avoid disputes among the owners.
Right.
It's very easy to think everybody understands what percentage of the company they own, how many shares they have, or what their responsibilities and rights are. But if you don't have that down in writing, or if you do have it in writing, but it's not very good, it's sort of an email back and forth and doesn't really match the concepts that are mentioned in
Right.
the corporate statutes and the LLC statutes, you can end up with a huge fight on your hands.
Right.
And so then you don't even get to a sale of the business. You've got to fight, you may have litigation filed against you by the upset owner who thinks they had 15% and then they find out they only have 10,
Yep.
or you think they only have 10. So it's just critical from the standpoint of keeping things running smoothly, not getting sidetracked in disputes. Documentation can help with that.
So let's move to a buy-sell agreement.
All right, sounds good.
'Cause, this one is where, as a certified valuator doing valuations, I'd say 90% of my business is focused on either buy-sell disputes with regards to that partnership agreement and or just fulfilling the duties and obligations outlined in that. But I find it is really important, and there's some really key drivers that you want to think about when coming to Erich or your corporate attorney to go through and put a buy-sell agreement together. But why don't you kind of go through your thoughts on buy-sell agreements?
Sure. Let me mention one thing up front. Folks who have formed an LLC may think, oh, I don't have a buy-sell agreement, I don't need one. A buy-sell agreement typically is a corporate document.
Right.
Everything we're talking about buy-sell agreements is also included within the operating agreement, or should be included within the operating agreement of an LLC. So this applies to both kinds of entities.
Yep, absolutely.
But in terms of what typically is in there, I mean, you've touched on the major item, which is having an understanding among all the owners as to what are the rules for transferring ownership of the entity. And this is important in at least two and probably a number of other situations. The first way that it's important is just in sort of ordinary life of the business and life of the owners, as people decide that their personal circumstances have changed and they may want to sell some part of the business, what are the rights of the company and the other owners to say, wait a minute, we want to buy that from you before you sell it to somebody that we don't know.
Right.
So that's one aspect. And that's a right of first refusal that is very common in buy-sell agreements and probably is the main reason people sign buy-sell agreements. The other is what happens if an owner dies, is divorced, goes through a bankruptcy proceeding where assets are distributed to other people, to creditors. In those situations, for different reasons, you want to be very clear about what rights the company has to buy that stock back.
And at
or
what
perhaps
price?
what obligation.
Yeah.
And at what price.
Right.
The buy-sell agreement probably should set forth some sort of formula because that will help somebody like you. Let's say you go to Brent as the valuation expert. He's going to want to know, well, is this supposed to be fair market value? Is it supposed to be fair value? Is it supposed to be a formula? And it'll depend on what's said in the buy-sell agreement.
So I think one of the things that when I'm talking with my clients and I'm referring them to Erich or somebody else to get a buy-sell agreement is really around valuation. For a smaller company, fair market value is a fairly easy value for the company to probably absorb, or the owners of the company. And the question I usually always ask my client is, what value, if you were to die tomorrow, what value would you want your spouse or your heirs to receive? And the highest level of value is a fair market value. And that's really was defined by Revenue Ruling 5960 and is the foundation for all valuations moving forward. Fair value can be the same but as fair market value, but it's a state-by-state issue, and not all states have a definition for fair value, so you've got to be careful. And then just a formula. So the larger the company, either the retirement of a shareholder, a death of a shareholder, where it usually falls on the corporation to purchase those shares back at that stated value. If you've got a majority owner, somebody who says, owns 75%, and it's a $30 million corporation, it's fairly easy to figure out that's a large capital event that the corporation may or may not be able to actually handle in purchasing those shares back. So there's got to be a lot of discussion around key man life insurance,
Yep.
how that's put together and resolved and brought back into the corporation for payment, is also of terms. So, it's not just a simple document to go through.
No, not at all.
And it should be well thought out, and it is the rights of the corporation, but also the obligations of the corporation or the option of the corporation on whether somebody's retiring, decides to sell, what the value is, and then something that we were talking about off camera, which is drag along, tag along rights involved in that as well. So for the minority owners.
So let's talk about that a little bit.
Yeah.
Some of the things that also go into a buy-sell, as you said, are drag-along and tag-along rights. Those are very common. Just a real quick explanation of what those are. A tag-along right is something meant to protect the minority owners. And it basically says that the minority owners have the ability, the right, to participate in a sale by the majority owner of part of that owner's stock.
Right.
So for example, if let's say there's a 75% owner and a 25% owner, and the 75% owner decides that she's going to go out and sell a third of her shares, to somebody else. Well, that under a tag-along right, the minority owner, the 25% owner, would then also have a right to require that 1/3 of her stock be included in that sale, so that the majority owner is not able to take money off the table and entirely leave the minority owner out. It's got to be, people are treated equally.
Right.
So that can be an important provision, again, from the standpoint of the minority owner.
And where I see it play out most of the time is where you've got 5 owners, the majority vote to sell the company in its entirety.
Yes.
Then the minority owners have to come along, which would be the drag along part. That's the drag along clause in it. So that's where I usually see this take place. But
no, that's right.
Yeah. So it can be, I don't know, a 10 to 12 page document. It doesn't have to be overly complex, but it has to be very clear. And everybody should really understand it. And if you are a business owner and you've got one in place and it wasn't well put together, it's a document you should have your corporate attorneys take a look at and bring up to snuff, because over time just things change. But again, example, California corporation, they're growing. They're probably going to be at around 50 million this year, and their shareholder agreement, we just went through the process of getting it redrafted because it really did not represent the value of the corporation to the actual shareholders. So it's something that you should review. If you haven't done it in the last 10 years, you should probably pull it out and read it and maybe send it to your attorney.
Let me mention another reason that people should update their buy-sell agreements, and this is as of right now. We're having this interview in December of 2023, so if you're viewing it later, this will be even more pertinent.
Yeah.
There's a new act called the Corporate Transparency Act.
Right.
Actually, the act is not new. It's been around a couple of years. But it goes into effect January 1, 2024. And it requires that corporations and entities of all sizes, regardless of whether you're privately held or public or whatever, file really very detailed ownership reports with the federal government. In order to file those reports, you have to be able to get the information needed for them from your owners and from those who control the entity. So one thing we are currently recommending that clients do is update their buy-sell agreements or shareholder agreements or operating and LLC agreements to put a clause in that requires each owner to provide the company with the information required by the federal act. And on top of that, and perhaps more important, if there is ever a change in this information, so if a shareholder moves, if they renew their driver's license, yeah, it's that kind of stuff.
Yeah.
They need to notify the entity right away because the entity has a very short time, typically 30 days, to file an updated report with the federal government. This sounds probably like, oh, this is just record keeping and not important. It's the reason for this law is to try to combat money laundering and to some extent terrorism. And the Congress deemed it important enough that they made this a criminal statute. So you can go to jail for 2 years if you just ignore it and don't try to keep the information updated for those in your corporation. So that's why this is so important as something that you may want to put in a buy-sell agreement.
Yeah,
otherwise.
we were talking off camera, and
Yeah.
we got our notice, and we tried to file, and you can't yet. So
Can't yet.
in the federal government's not
Right.
quite there yet. But I did not realize it was a criminal act.
It is a criminal act. Yeah.
Okay.
So or I should say, it has criminal penalties.
Okay,
So
there you go. Yeah.
So that's a fun one, and one we'll mention that is more beneficial to everybody, and should be a reason to have a buy-sell agreement, is if you do elect S corp status, which can really save you a lot of taxes. One thing you want to have in your buy-sell agreement is that any transfer of stock will be allowed only if it doesn't negate the S election.
Correct.
And so that's something that, again, any S corp should have, or any LLC that is taxed as an S corp,
Right.
should have in their operating agreement or buy-sell agreement.
I think the other thing we talked about was dissolution of marriage. So
Yes.
you'll want to have a spousal consent form in
That's
there
right.
as well. And that really will guard you for dissolution of marriage. But I also think it helps with bankruptcy and a few other things.
Well, one reason it helps, even if your marriage is in great shape, and I hope everyone's is, if you live in a state that is a community property state,
Right.
then you almost have to have that spousal consent in order for the restrictions on transfer to be effective. So there are a number of reasons for having a spousal consent in a buy-sell agreement.
Great. Well, Erich, this has been great. I really appreciate you stopping by and very educational. I'm going to leave Erich's contact information and bio in the comment section below. And again, I can't recommend Erich highly enough. Again, one of the things I really appreciated about Erich is, one, his knowledge base, but two, his firm, Miller Nash, has got a tremendous amount of resources. So depending on the deal size, and I usually, our kind of sweet spot at the CBB Group is for businesses less than $20 million in enterprise value. But if you're even a publicly traded company, Erich's staff and his firm has the expertise to actually go through merger and acquisition or capital raise or a lot of the other things that go with the bigger firm. So again, really appreciate you stopping by, and thanks for your expertise and
Brent,
your time on a Friday.
Thank you. It's always a pleasure dealing with you
Yeah,
and the
absolutely.
CBB Group.
Thank you. All right. Level, everything you needed to know about corporate formation, corporate governance, the Corporate Transparency Act of 2020, and why it's important for you as a business owner. Now, I want to thank Erich for dropping by on a Friday afternoon and spending time with the channel discussing these topics and more. I'm going to leave his contact information below, and if you've got any questions, please feel free to drop him an email, and I know he'll get back to you. And if you're looking for corporate counsel, can't recommend Erich highly enough. So with that, if you got something out of this video, please feel free to hit the like and subscribe button. And with that, we'll see you in the next episode.